This would not be sufficient per se to uphold the objection to admissibility raised by the respondent on the basis of the clean hands doctrine. The court therefore concludes that Pakistan's objection based on the said doctrine must be rejected. The court further notes that Pakistan has relied on the judgment of the Permanent Court of International Justice in the factory at Chorso case in order to advance an argument based on a principle to which it refers as ex turbi causa non oritur axio. However, in that case, the Permanent Court referred to a principle, and I quote, generally accepted in the jurisprudence of international arbitration, as well as by municipal courts, that one party cannot avail himself of the fact that the other has not fulfilled some obligation if the former party has, by some illegal act, prevented the latter from fulfilling the obligation in question, end of quote. With regard to this principle, the court is of the view that Pakistan has not explained how any of the wrongful acts allegedly committed by India may have prevented Pakistan from fully fulfilling its obligation in respect of the provision of consular assistance to Mr. Jadhav. The court therefore finds that Pakistan's objection based on the principle of ex turbi causa non oritur axio cannot be upheld. This finding leads the court to a similar conclusion with regard to the principle of ex injuria jus non oritur, which stands for the proposition that unlawful conduct cannot modify the law applicable in the relations between the parties. In the view of the court, this principle is inapposite to the circumstances of the present case. Accordingly, the court finds that Pakistan's third objection to the admissibility of India's application must be rejected. In light of the foregoing, the court concludes that the three objections to the admissibility of the application raised by Pakistan must be rejected and that India's application is admissible. The court now turns to the merits of India's application. In this regard, the court recalls that Pakistan does not expressly raise any objection to the jurisdiction of the court. It notes, however, that Pakistan does advance several contentions concerning the applicability of certain provisions of the Vienna Convention to the case of Mr. Jadhav. The court considers it appropriate to address these arguments first before turning to the alleged violations by Pakistan of its obligations under Article 36 of the Vienna Convention. The court notes that Pakistan's contentions regarding the applicability of the Vienna Convention are threefold. First, Pakistan argues that Article 36 of the Vienna Convention does not apply in prima facie cases of espionage. Secondly, Pakistan contends that customary international law governs cases of espionage in consular relations and allows states to make exceptions to the provisions on consular access contained in Article 36 of the Vienna Convention. Thirdly, Pakistan maintains that it is the 2008 agreement on consular access between India and Pakistan rather than Article 36 of the Vienna Convention, which regulates consular access in the present case. The Court will address each of these arguments in turn. With regard to Pakistan's first contention, the Court begins by noting that India is not a party to the 1969 Vienna Convention on the Law of Treaties, whereas Pakistan signed that convention on 29 April 1970, but has not ratified it. Accordingly, the Court will interpret the Vienna Convention on Consular Relations according to the customary rules of treaty interpretation, which, as it has stated on many occasions, are reflected in Articles 31 and 32 of the Vienna Convention on the Law of Treaties. The Court observes that neither Article 36 nor any other provision of the Vienna Convention contains a reference to cases of espionage, nor does Article 36 exclude from its scope, when read in its context and in light of the object and purpose of the Convention, certain categories of persons, such as those suspected of espionage. The object and purpose of the Vienna Convention, as stated in its preamble, is to, I quote, contribute to the development of friendly relations among nations, end of quote. The purpose of Article 36, paragraph 1 of the Convention, as indicated in its introductory sentence, is to, I quote, facilitate the exercise of consular functions relating to nationalities of the sending state, end of quote. Consequently, consular officers may, in all cases, exercise the rights relating to consular access set out in that provision for the nationalities of the sending state. It would run counter to the purpose of that provision if the rights it provides could be disregarded when the receiving state alleges that a foreign national in its custody was involved in acts of espionage. The Court thus concludes that when interpreted in accordance with the ordinary meaning to be given to the terms of the Vienna Convention, in their context and in light of its object and purpose, Article 36 of the Convention does not exclude from its scope certain categories of persons, such as those suspected of espionage. In view of this conclusion, the Court need not, in principle, resort to supplementary means of interpretation, such as the travaux préparatoires of the Vienna Convention and the circumstances of its conclusion, to determine the meaning of Article 36 of the Convention. However, as in other cases, the Court may have recourse to the travaux préparatoires in order to confirm its interpretation of Article 36 of the Vienna Convention. During the discussions of the International Law Commission on the topic of consular intercourse and immunities, there was no suggestion that Article 36 would not apply to certain categories of persons, such as those suspected of espionage. Draft Article 30A, which served as a basis for Article 36 of the Convention, was discussed by the Commission in 1960. It provided in the relevant part, and I quote, that the local authorities shall inform the consul of the sending state without delay when any national of that state is detained in custody within his district.